So welcome to this Brodie's webinar. Today we're looking at legal privilege. We'll talk about what that is, why it's important, how it can be lost, and finish by looking at some recent decisions on the subject and how they can be of value to us. The key point about legal privilege is the power that it gives you. Anything that's not privileged is disclosable or discoverable. So courts and tribunals have the power to order that documents can be released by parties to a case or even third parties who have no interest in it. And employees have the right to demand certain information about themselves under the Data Protection Act. And normally if you refuse these requests, you'll be acting unlawfully. But documents which are privileged don't need to be given up in response to a DSAR or a tribunal order. You will only release them if you choose. Now, it follows that you can't claim a document is privileged unless it's confidential to you. And if you do want to claim privilege, the onus is on you to prove that the document has that status. So we'll now look at two types of legal privilege: legal advice privilege and litigation privilege. The first of those, legal advice privilege, applies to communications between a lawyer and their client that involve requesting or giving legal advice. Now, it's very important to know what lawyer and client mean in that context. A lawyer must be a qualified lawyer, so it has to be a member of the legal profession. Now, that will include a solicitor, but how about a trainee, for example? Well, it will if that person is supervised by a qualified lawyer. And it should also include a barrister and even in-house counsel if they are legally qualified and giving legal advice and not making some other more general type of communication. But privilege won't apply to internal HR or external consultants. And for this reason, getting legal advice about a situation from a lawyer is often more valuable because you can't be asked to disclose it later on. Now, who is the client here is equally important. For you as an individual, you'll only be the client if you're authorised to seek and receive legal advice on behalf of your employer. So the bigger your organisation, the greater the risk of privilege not applying to someone who happens just to be in touch with a lawyer or someone who receives a copy of the legal advice further down the line. This has been criticised judicially, but it remains the rule. The rule also applies to the process of creating or gathering documents to send to the legal advisor. They will only be privileged if the person doing that has the same authorisation. So be careful about delegating. And also documents that you create but don't send to the lawyer as part of the request for advice will not be privileged. The privilege also won't apply to communications outside of that fairly narrow and closely defined lawyer and client relationship. So it won't cover exchanges between a lawyer and someone who isn't the client, and it won't cover communications by the client to any other party. And as we've touched on, it may not even cover circulation of the advice within the organisation to people who aren't authorised. But what it does have in its favour is that this type of privilege can apply at any time. There doesn't have to be a dispute or litigation in play or contemplated.
The second type of legal professional privilege is litigation privilege. So litigation privilege arises from the principle that a litigant or a potential litigant should be free to seek advice or evidence without being obliged to disclose the result of their research to their opponent. It will cover communication between a lawyer and their client, as with legal advice privilege, but it will also extend to communications between you as the client and third parties, or between your lawyer and a third party, as may happen, for example, when an expert witness is being instructed. It applies to advice that's sought or received, but it also applies to all other types of documents that might be produced. Litigation privilege is wider in scope than a legal advice privilege in some respects, so it's not as restrictive in terms of the people that are involved because it is possible to involve third parties. But on the other hand, the scope of litigation privilege can be narrower than legal advice privilege in two ways. Firstly, legal advice privilege can attach to communications at any time, whereas communications will not have litigation privilege unless litigation is pending, reasonably contemplated, or existing. It's been noted in the case law that the chance of litigation does not need to be greater than 50%, but it has to be something that could well give rise to litigation in the future. And that's something that we'll look at in one of the cases that we'll consider shortly. The scope of litigation privilege can also be more limited in the sense that legal advice privilege can generally cover anything that a client may be looking for advice on, whereas in order for litigation privilege to apply, the document or communication must be made for the sole or dominant purpose of the litigation. Now, that might be obvious because, for example, communication is being prepared specifically in response to a threatened claim, but it might be less obvious. Documents that are produced, for example, as part of an internal investigation or fact-finding process, such as a grievance or disciplinary procedure, are less likely to have been created for the sole or dominant purpose of litigation. Now, turning to consider ways in which privilege can be lost. The first is that if a document is released into the public domain, it will lose confidentiality. And as legal professional privilege only attaches to confidential documents and communications, the loss of confidentiality is likely to amount to a waiver of privileged status. Privilege can also be lost intentionally when you decide to waive privilege, for instance, by placing privileged material before an employment tribunal. So if, for example, you were to disclose an expert report that's perhaps favourable to your case. If you do decide to waive legal professional privilege, though, you should be aware that you may be obliged to disclose other related communications and documents in order to prevent the court from being left with only a partial picture. So, for example, in one case, as part of the disclosure process for an employment tribunal, an employer disclosed a note by their HR manager summarising a call that she had had with their external solicitor about dismissing an employee. And the employer also disclosed a draft dismissal letter, but redacted the solicitor's comments on the letter on the basis that those comments were covered by legal advice privilege. The EAT held that that amounted to impermissible cherry picking. The company's reason for dismissing the employee was of paramount importance in that case. So it was held that to redact comments on the outcome letter, having disclosed earlier advice that had been taken by the HR manager, was to present a partial or potentially misleading picture, which is not something that employers are entitled to do. The second way that privilege may be lost is if advice is passed on. As Brian has already mentioned, where an internal legal team is, for example, passing on legal advice to other employees in the organisation, such as the HR contact, they should be including wording to say that the document content is confidential and privileged, and provision of the document does not amount to a waiver of privilege. But ultimately, it's worth bearing in mind that even if you do include those caveats, there is still a risk that privilege can be lost by passing it on. So it's always safer to restrict circulation of privileged material to only those personnel that really need to see it. And finally, another area in which there's been some debate about whether privilege can be lost is as a result of the so-called inequity principle, which is considered in the case of Curlis against Shell International. So Mr. Curlis suffered from diabetes and sleep apnea, and he'd been employed by Shell for a number of years. After he had been dismissed and in the course of tribunal litigation, he was sent an email anonymously in the post, which contained advice from Shell's lawyers to Shell that a genuine redundancy exercise could perhaps be used as an opportunity to dismiss him in order to avoid his continuing complaints about disability discrimination. The EAT held that the email had lost privilege because it was recording legal advice that a redundancy exercise could be used to cloak what would effectively be a dismissal for discriminatory reasons. The EAT held that discrimination that's advised or commended to a client may be so unconscionable so as to render it contrary to public policy, meaning that it should not then benefit from privilege. Shell, however, appealed to the Court of Appeal, and the Court of Appeal took a different view. They held that the email was privileged and it contained the type of advice that employment lawyers give day in, day out, and was not part of a dishonest plan to dismiss Mr. Curlis. There was clearly a difference in interpretation in the wording that was used between the EAT and the Court of Appeal, but the Court of Appeal judgment tends to suggest that the court will be reluctant to interfere with privilege that attaches to communications between a client and their lawyer on grounds of inequity, unless there are exceptional reasons for doing so.
Now we're going to look at a couple of recent decisions now, which are particularly interesting and useful reminders of some of the principles that we've already touched on. So the first case is the University of Dundee against Professor Chakraborty. And this case raised quite an interesting question, I think, of whether a document which isn't privileged to begin with can later become privileged after legal advice is obtained, which results in a new version. So in this case, the claimant, Professor Chakraborty, made an internal complaint of race discrimination against a colleague, and that was investigated and an investigation report was prepared. And that was sent to external lawyers who recommended some revisals, and it was the amended version which was sent to Professor Chakraborty. Now, when he later raised an employment tribunal claim, he applied for disclosure of the original version of the investigation report because he wanted to see what the investigator had written before the lawyers recommended any changes. But the university refused that and said that by comparing the two versions of the report side by side, it would be tantamount to disclosing the legal advice they'd obtained. But the Employment Tribunal disagreed, as did the Employment Appeal Tribunal, and finally so did the Court of Session earlier this year. But there's some interesting points I think we can take from the court's judgment. The first of those perhaps is that material usually will be privileged if its disclosure will allow someone to find out what was the legal advice behind it. So theoretically, a non-privileged report could become privileged later on, but it just wasn't realistically possible to tell in this case what advice had been given by comparing the two versions side by side. So at best, all you could do was guess, as the court said. Secondly, I think, interestingly, the court found that in any event, privilege in the legal advice had been lost when it was passed to the internal investigator. So again, this emphasises the point that and the importance of only sharing legal advice to people who are properly authorised to receive it. Now, the investigator wasn't the point of contact with the lawyers, and they weren't so authorised, so they didn't count as the client. And I think that's a really important point to bear in mind whenever you're getting legal input into an internal process like an investigation or a grievance. And thirdly, the university was also deemed to have waived privilege in another way, which was by expressly stating in the investigation report that it had been revised following legal advice. So don't do that if you're ever in a similar situation.
And I'm just going to cover the case of Trentside Manor Care Limited against Raphael, which gives some insight into the point at which litigation privilege may attach to communications in the context of a workplace dispute. So Ms. Raphael made a flexible working request in May 2018, which was agreed around the beginning of June. However, 2 weeks later, she was suspended for suspected misconduct, and that ultimately led to her dismissal in August. Ms. Raphael brought claims of unfair dismissal and disability discrimination, asserting that the real reason for her dismissal was because she had made the flexible working request, which in turn related to her disability. In the course of tribunal proceedings, Ms. Raphael applied for disclosure of the communications between TMC and their advisors, who were HR consultants that were not legally qualified. TMC objected on the basis that the communications were privileged as a result of legal advice privilege and also litigation privilege. Now, the tribunal and the EAT both held that there was not legal advice privilege because the communications in question were not exchanged between TMC and a qualified lawyer. But I suppose more interestingly, the tribunal and the EAT found that while litigation privilege attached to the communications between TMC and their advisors after Ms. Raphael had been suspended, it did not attach to the communications in the period between her having made the flexible working request and her suspension. It was held that while it was advisable for TMC to have taken advice on flexible working requests and reasonable adjustments, there was no reason at that stage to believe that litigation was anything more than a possibility. TMC submitted that given Ms. Raphael had sought flexible working by way of reasonable adjustment and the complexity and potential expense involved in defending a disability discrimination claim, it was plain that the correspondence with its advisors was entered into in reasonable contemplation of litigation. That argument, however, was not accepted by the EAT, who held that the mere fact of taking advice on issues which could in principle be the subject of employment tribunal proceedings is not enough to trigger litigation privilege, nor is the fact that the issues might be complex or that the employer may be on the hook for substantial compensation if it gets them wrong. So it goes back to the point really that litigation must be reasonably contemplated at the point that the advice is given, and that'll be particularly important where there isn't going to be protection by way of legal advice privilege, as in this case. Another type of privilege that's likely to be highly relevant for HR professionals is without prejudice privilege. So we think about this in the context of wanting to have an off-the-record conversation with an employee. For example, you may want to propose termination of employment on mutually agreed terms rather than go through a disciplinary capability or redundancy process. Or employees that are potentially facing a formal process may wish to initiate a confidential discussion with you about an exit on agreed terms. Now, without prejudice rule is intended to encourage party to settle their dispute without having to go to court by providing reassurance that anything that's said during those negotiations will not be used against them in subsequent legal proceedings. However, the protection of without prejudice privilege only applies where the discussions are a genuine attempt to resolve an existing dispute between the parties. The question of whether there's an existing dispute will depend on the circumstances. So, for example, if an employee has threatened litigation or has already taken that step and lodged a tribunal claim or commenced ACAS or reconciliation, that's likely to constitute an existing dispute. But if, however, you're thinking about offering a settlement agreement to an employee who perhaps has been underperforming, but there haven't been any formal performance discussions, and the employee is likely to perceive that as coming completely out of the blue, then it's very unlikely that that would constitute an existing dispute, and the without prejudice rule may not apply in those circumstances. But that actually may instead be covered as a protected conversation. So protected conversations were created by statute in 2013 to allow for greater flexibility for employers to have confidential discussion as a means of bringing an employment relationship to an end. There's crucially no requirement for an existing dispute, so it extends further than the protection that's provided by the without prejudice privilege rule. But often protected conversations will be had against a background of an existing dispute, which is entirely permissible. So there may be cases where you have both protected conversation protection and without prejudice privilege. Protected conversations provide protection only in relation to unfair dismissal claims, though the fact and content of a protected conversation can be referred to in other types of claims, such as, for example, automatically unfair dismissal or discrimination claims. And that's different from the without prejudice rule, which protects discussions in all types of claims. So if without prejudice privilege can be used, that's likely to offer slightly stronger protection from the communications potentially becoming admissible.
So we'll take a look now at a recent case on the without prejudice principle at the EAT. This is the case of Mr. Evanson against his employer Sheldabau. Mr. Evanson met with his employer to discuss possibly retiring, and they discussed his outstanding holiday retirement at the same point. Now, for some reasons undisclosed in the judgment, he had a very large number of days accrued, which he hadn't taken. The company suggested the number was 168 days and offered him £68,000 for that. But he said it was closer to 200 days and was asking for £81,000. The company agreed that amount in principle, but the negotiations broke down later on over other aspects of his termination package, which ultimately couldn't be agreed. So Mr. Evanson raised a tribunal claim for his holiday pay, and in the process of that, he referred to the offer of £68,000, which had been made by the company. Now, the company, perhaps unsurprisingly, argued that it had been made without prejudice and it shouldn't be part of his case. But the tribunal disagreed, and so did the EAT when the company appealed. Now, again, I think we can take some useful points from this recent decision about when an offer will or won't be without prejudice. So again, the question of whether the parties were contemplating litigation at the time was central, and they weren't found to have been doing that here. There was no suggestion that Mr. Evanson's departure in itself was contentious. It was a mutually agreed termination, and most of the other terms were agreed at the same time. So in essence, it was found that they were just having a commercial discussion about one aspect of it. The distance between the parties was relatively narrow, and that was seen to be valid as well. It was reasonable to think that they would reach agreement on a figure. And the tone of the discussion overall was looked at. There was no sense of hostility between the parties, and there was a sense of expectation that all of the issues would be resolved. There was reference to it being a gentleman's agreement. And finally, nobody in the course of those discussions used the term without prejudice. Now, that won't magically give you immunity, as I think we've made clear, but it does speak to your intentions at the time. So it's better generally to use it than not. And interestingly, another point was that the fact that the employer wanted the terms to be reflected in a settlement agreement didn't influence the tribunal's view about the discussions being open and disclosable. So just to round up, that's where we are for now, at least. To sum up today's message, if we can, legal privilege is a valuable thing to have. There are different types of privilege which apply in different situations, involving different people and at different times. And just as it's a valuable thing to have, privilege can be a damaging thing to lose. So be careful. So we'll now move on to see to deal with any of your questions now. One has been raised which asks what are the factors that could make it more likely that communications in an internal grievance process could be privileged. Now, that's quite a common situation, admittedly. Assuming that there's no legal advice privilege involved if everything's internal, because of course, if in-house counsel are involved, then there may be legal advice privilege attached to any requests made to that person or advice given. But assuming that's not the case, then you're left to consider whether litigation privilege might apply. Now, you might want to look at such things as the gravity of the allegations being made in the grievance, whether those could be framed or recognisable as legal complaints that could be made to an employment tribunal. Has the person taken legal advice and told you that? Or whether they've been in touch with ACAS about the situation already. Sometimes a person will quite explicitly say that they recognise they could make a claim, or that that would be their alternative if they don't reach a satisfactory outcome. And that may be said explicitly or perhaps more indirectly. The question of what outcome a person is looking for might be relevant as well. Is that at the more extreme end of the spectrum, such as a large payment and an exit from the business, or is it something more modest? And just going back to Mr. Evanson's case, what is the tone of the communications and the discussions? Is it amicable and constructive, or is it more strained? So it's unlikely that any single factor will give you the answer, and you'll probably need to consider the whole picture. Now, someone else has raised the question, if a legal advice note is shared with a line manager, for example, by HR, is the privilege lost? Louise, do you want to take that one?
So it depends on the circumstances. So I suppose ultimately, if it's being shared by the line manager, I suppose it depends why it is that it's necessary to share it with the line manager. I would think very carefully before doing that. But ultimately, if you are going to share it, if you think that there are reasons that it requires to be shared, then it's about making it very clear that it's still privileged, that you want it to be kept confidential. Those are the ways that you would mark it up, essentially. I don't know if you've got anything to add to that, Brian.
I think that's right, but you have to accept that there would be a greater risk if a line manager is not one of those authorised people in the sense of the lawyer-client relationship. If they don't represent the client in that sense, that quite narrow sense, then there would have to be a risk that privilege would be lost if it's shared by someone who is authorised to communicate with the solicitors, like an HR director or business partner or a director of the business, to somebody else in the organisation. I think that has to be recognised. And I think a similar question, should in-house lawyers always be marking advice as privileged? Even if it doesn't seem initially something is going to be a disputed issue, it might be, or is that overkill? Well, as I touched on in relation to the Evanson case, it's probably better to use those terms than not, but they won't give you blanket immunity. So I would say it's good practice as long as you don't get a false sense of security from doing it, because it's the legal test which will apply, and that will go wider than just the wording you use in a document. So with that said, we wish you a very good afternoon. Thank you.
Thank you.